This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
In the United States, a judge will determine whether to allow a digital forensic expert to testify to an opinion about their expert opinion about what was on this phone and when. Did this person have knowledge of this file based on what they found on the phone? Is this everything that was on the phone at the time? And how we determine whether that expert method is reliable through validation, et cetera.
When it comes to verification and validation, when we talk about the forensics, this is really the sort of bedrock and where forensics begins. Verification and validation are important. So in simple terms, validation means that a tool works the way it's supposed to, and verification means the tool worked the way it was supposed to on an occasion. We're going to talk in a minute about a hammer and a nail. So if you wanted to validate a hammer, what you would say, okay, what's the purpose of the tool? The purpose of the tool is to take a nail and drive it through wood. So you build a tool, and your tool is a hammer. And you go out there and you practice and you say, yeah, every time I hit the nail the right way being key, it's driven through the wood. So that would be validation, your tool works. Verification is going back and make sure your tool worked right on an occasion, and you would often do that with other tools or with other people. So verification and validation, bedrock principles, and this is the first time I'm going to tell you why I think live testimony is important. I had a case one time where there was a federal agent who was working with a prosecutor, and if you were to look at the gentleman's resume, it was very impressive. Again, he worked for a national law enforcement group. He had a master's degree in forensic science, and he had been practicing for 5 years. My second question on cross-examination, and again, this is the chance where I get to confront and take a look at the government's expert. I said, sir, I want to talk to you about verification and validation. He said, that's great. I said, sir, you're familiar with these terms? And he said, I've never heard them before. Now, this is not the answer that I was expecting. This just proved that, and it turned out that this gentleman couldn't support the opinion he wanted to give in court. But without live testimony, we would have never figured that out. And so that's just one of the plugs I wanted to have for live testimony and why it's hard to rely sometimes simply on a resume.
In other words, without a live witness, you would just have a paper report that would come in and everyone would assume that's reliable evidence. But having the person who created that report in court, you were able to show he didn't really know what he was talking about, and the conclusions in his report were not reliable.
There's a question about live witness testimony at trial. You could imagine possibly doing a deposition of an expert like that and getting some interesting responses. But in criminal cases, it's really the norm that you don't have any chance to depose witnesses unless somebody is, very ill or something. COVID-19 may change some of those norms, but basically in criminal trials, this is your only chance is real-time questioning, either in a motions hearing right before trial or at trial itself. I just wanted to mention the 3 cases that in which the Supreme Court has laid out the requirements for admission of expert testimony in terms of reliability, and then show you how these cases have been now codified in what is now Federal Rule of Evidence 702. And even though that's only binding in the federal courts, it's been very influential, and most states have adopted the Daubert standard. So in 1993, the Supreme Court interpreted the federal rule 702, which relates to admissibility of expert testimony, as requiring a showing of evidentiary reliability, which they said was the same thing with respect to a scientific expert. It basically means showing that the expert's method is scientifically valid. Sometimes in the literature that's called foundationally valid. Is the method valid? Before we even get to how the analyst is. In General Electric versus Joyner, 4 years later, the Supreme Court said, by the way, this reliability requirement not only relates to the method itself, but also the way in which the method was applied and the conclusions that were actually drawn by the witness in this case. And if the witness unreasonably applies a method, then that is something that could actually be a barrier to admission. So it's not just that it looks bad for the expert. The expert may not be able to testify at trial. The jury will never hear this evidence if a judge determines by a preponderance of the evidence, more likely than not, that the method is reliable. And then Kumho Tire in 1999 said that this reliability requirement applies not only to scientific testimony, but all expert testimony. Why did they feel the need to do that? Because some experts don't think of what they do as, quote, science. It may be a technical area. In our forensic fields, you have actual forensic experts with respect to, say, firearms comparison, who actually say that what they do is an art, not a science. And it used to be their way of trying to get around evidentiary requirements for scientific testimony. And the Supreme Court says, no, either way, you got to show that the method is reliable. And so now Federal Rule 702 has basically codified all three of those cases by saying the expert has to be qualified, the expert has to actually say something that helps the trier of fact. It can't be something that the jury can figure out on their own. The testimony has to be based on sufficient facts or data. The testimony has to be based on a method that is reliable, and that method has to be reliably applied in the case at hand. And so this really gets to the method versus the analyst.
If we were to take this out of the courtroom for a second, if you were going to buy a new home and the carpenter who was putting together the frame of the home, you would want to make sure that he or she was following the same procedures that other carpenters were. And you would want to do that because carpenters have been doing this for a long time. You would want to make sure that they were using the right materials and that they were using the right materials in the proper way. That's really what we want when it comes to forensics in the courtroom also. So we talked about the tool. So the tool in this case is a hammer. The method would be an overhead swing. And then the second part would be hitting a nail. But why this picture turned out to be great, does anyone notice what's wrong with this picture? I'll tell you, that's a screw. Do you use a hammer on a screw? No. So this would be an example of using the wrong tool based on what you were trying to accomplish. And it's interesting because screws look a lot like a nail and they have the same function. It's really to go through wood to bind more than one thing together. But there are different techniques and different tools you would use to do that. So this turned out to be a perfect example of when this can go awry. One way that you can validate a tool is you can have someone else do it for you. So commonly there are groups out there that will say, I use this digital forensic tool. I followed the directions and then I looked at the results and the results were valid, meaning they are what I thought they would be. That's great. That's an example of validating a tool. I had a case recently where an agent used a brand new tool and it had not been validated. And the agent had a separate thing he could have done. He could have done a validation himself. There are tests out there that are publicly available, and you can use data and you can make sure the tool works the way it's supposed to work. This guy did neither. He couldn't prove that the tool worked the way he said it would work. What he said was, yeah, I used this tool a bunch and every time it worked. And I was like, but how do you know it worked if you never compared it to other tools? And he was like, but it's really pretty. Like the output and the report was really nice and it was expensive and you really liked it. And I was like, yeah, that's not validation. And the judge agreed. The judge ultimately found in a Daubert hearing that the person could not testify in a trial because the tool they were using had not been validated. And the reason that the court found that is because when we're dealing with Daubert cases, really what the court wants to know is this reliable? And for us, validation and verification help get to reliability. And so if we don't know the tool you're using works the way it's supposed to, and we don't know if you used it right on the time that you used it, then how can you say it's reliable? And so that's really where this comes in. And hopefully this example helps make sense.
Just wanted to mention one of the reports that's most recent about forensic evidence. The report is mostly about pattern evidence and not necessarily digital evidence. It gives you sort of a template from thinking about these different layers of validation. And also the fact that whether we're talking about a human analyst who is just looking at two bite marks and trying to figure out if they came from the same person, or if we're talking about digital software or some complex DNA software, we're still talking about the same concept of, is this method foundationally valid? And did this analyst apply the method correctly? And so when we talk about a machine being a black box, or there be something, something wrong with software output, we could still use that same terminology when it comes to human analysts. So I just wanted to show a couple of things that will put this conversation about digital and machine evidence into perspective. So this report to the president from the President's Council of Advisors on Science and Technology, PCAST, called the PCAST report, came out in 2016, and is really the most recent pronouncement from a nationwide body of scientists about the foundational validity of various types of forensic pattern evidence, like latent fingerprint analysis, like firearms comparison, like DNA. And it talks about black box testing and the need for testing of a method to determine how many times it gets it wrong, how many false negatives, how many false positives, and to develop an actual error rate. And you'd want to know the error rate of software as well. So you could do black box studies with respect to software that's used to analyze pretty much anything, including DNA. I wanted to give an example of a high-profile error that made the headlines in the United States that I think shows you both the problems with a method and the problems with an analyst, and also the sort of intersection between humans and machines. So in the United States, when, let's say, the FBI, the Federal Bureau of Investigation, is trying to sees a fingerprint at a crime scene and is a latent fingerprint and tries to figure out whose prints it might be, they take the print off of the surface where they find it, and they can run it through this huge database they have of millions of people's reference prints. And this automated system spits out, let's say, the top 10 matches. And so there was a case, the Madrid train bombings in 2004, the terrorist attacks. They didn't have a suspect, but they found latent prints on a bag. I think it was a bag of explosives, that they thought belonged to the perpetrator. The FBI put that print through the automated system. It came back with the top matches. The FBI analysts, who are generally the top of their field, looked at these and determined that there was an absolute match to this person, Brandon Mayfield, who was the lawyer in the United States, in the state of Oregon. And they said, we got our guy. He's the Madrid train bomber. And the Spanish police said, are you sure about that? And so the FBI looked and they said, well, look, he's a terrorist, I guess. And he hasn't left the country in a long time, and they found that to be suspicious. So he was still their suspect until the Spanish authorities found someone else who matched even better, and they determined that that person was actually the perpetrator. And so Brandon Mayfield, the FBI acknowledged, was falsely accused of being the bomber based on this mismatch, which they were absolutely sure was a match. There was a big Inspector General report about this case, but the thing I wanted to highlight was one concern that the Inspector General had about something that we might call automation complacency, the idea that a machine spit out these top 10 matches, and the human who was looking at these matches assumed that the perpetrator of the bombings surely had to be one of the 10 matches. And so they just picked the one that was the best match, and it was Mayfield. But really, they should have considered the possibility that the real match wasn't in the database at all, which turned out to be the case.